And before the break, I told you we're going to get into a conversation about the dismissal of the petitions for the removal of the chairperson of the Electoral Commission and her two deputies, as well as the special prosecutor. This morning, we've been joined by Nana Agyei Baffour Awuah, as Member of Parliament for Mensa South. Felix Kwachio-Fosu, who's Minister for Government Communications, will be joining us shortly, as well as Suleiman Abrahima, who's Executive Director of the Media Foundation for West Africa. But let me start off with you, Nana Agyei Baffour Awuah. Good morning, and thank you very much for joining us.
Thanks for having me. Good morning, my brother.
Great, Nana. So let's start this way. Now, what's your initial reaction to the dismissal of these petitions?
In my humble view, they are good because when you look at some of the narratives that have preceded the presentation of the petitions, it appeared as it didn't seem to be one which was well grounded. The petitions are supposed to be in camera, so the content mostly unknown. However, in this instance, snippets of what it contained had come out because of persons connected to it or interest groups that were connected to it. And so there was an idea as to the basis on which they had been sent, right? And I have always maintained that if you look at Article 146 and the decisions that have come out of it, prima facie is not a decision that should become too lightly. And I stood by that position so far as these ones were also concerned. And so I think that it is that position which seemed to be at play that, and indeed when you look at the letter from the presidency referencing portions of what the Chief Justice has stated, it is obvious that they have come to the conclusion that the threshold for prima facie, threshold for the establishment of a prima facie case under Article 146 is quite high. And so it is good, except to say that threshold was not made to apply in the case of Justice Gertrude Tokonu. And so one would ask why the threshold was lowered in the case of Justice Tokonu, but the threshold in these instances, right, was considered to be what it should be. And so that would be the lingering question. Well, otherwise, it's a very good position.
Okay.
Indeed, also, what may be coming out of it, again, because of the commentary that perhaps may have preceded it, particularly in relation to the case of the Electoral Commission. If you recall, in the case of the Electoral Commission, there have been some commentaries by big wigs within the NDC, right? Mr. Mustafa Bande, Mr. Johnson, the chairman of the NDC, who have taken the position that the Electoral Commission should be removed. The Electoral Commission and her deputy should be removed. Some of us came out to say that, look, if that position is allowed to hold sway, then we are going to weaken institutions of state, right? We do not know whether the positions of these persons who are big wigs of the NDC have changed. Hence, what perhaps has happened, right? Otherwise, it may be just President Mahama wanting to now play the role of a statesman because this is his legacy here. He doesn't want it to be tainted. He doesn't want his record to be replete with removals of not just head of an organ of government, but also independent constitutional and statutory bodies.
Okay.
So perhaps this is President Mahama, right, wanting to take the high ground instead of partisan pettiness. And so it is very good.
Now, let me say that we've been joined by Felix, who's Minister of State in charge of Government Communications, and also Suleimana Brahima, who's Executive Director of the Media Foundation for West Africa. Good morning, Felix. Good morning, Suleimana.
Good morning, man.
Thank you for having me.
Great. Now, let me just get back to you, Agyei Baffour Awuah, because you talk about, now, if you look at the letter dated 17th February 2026, addressed to one of the petitioners, it says, while the allegations raise serious constitutional and administrative questions, they do not, on their face, meet the threshold for a prima facie determination of stated misbehavior or incompetence warranting that a committee be set up to inquire into the petition. Now, they say these allegations raise serious constitutional and administrative questions. Somebody would argue, isn't that the more reason it will be important to actually set up a committee to then go into these allegations? Agyei Baffour Awuah.
Exactly. Because you see, the question is there a code of conduct? If there is a code of conduct, so the allegations, are they infractions of the code of conduct? If they are not infractions of the code of conduct, are they infractions of a statute? Right? Here, there's an admission that it's an infraction of the Constitution. Right? There's an infraction of there's an administrative misjudgment. Okay? Now, are you saying that a breach of the Constitution is not an issue? Don't forget, in the case of Justice Stockholm, it was statutory breaches. In some instances, what they considered to be moral infraction, right? Or what is considered to be a breach of the expectation of the office of the Chief Justice. And so, where there has been a specific breach of the Constitution, you think that it doesn't establish a prima facie case. That is why we have stated that, look, this issue about what constitutes a prima facie breach in respect of Article 146, we think that it should be reduced into law. Unless it is reduced into law, it becomes the discretionary power of whoever is making the decision.
Okay.
In the case of Superior Court, judges of the Superior Court of Judicature, or heads of institutions, statutory bodies, or independent constitutional bodies that have that are equivalent to the position of judges of the Superior Court, it becomes the discretion of the Chief Justice. And in the case of the President, in the case of the Chief Justice, it becomes the discretion of the President in consultation with the Council of State. And this is where it is not good. Otherwise, we risk a situation where different standards are going to be applied to different people based on the disposition of whoever is exercising that discretionary power and what he thinks of that person. And so this raises fundamental questions, and I think that we need a statute to resolve these things, because we can't have a situation where different principles or standards will be applied to different Ghanaians holding the same or similar positions.
But Agyei Baffour Awuah, if you say based on this, you support that there be the need, there probably is the need for a committee to look into it. How then do you, make the earlier comments that it's very good that the petitions have been dismissed? Because in one instance, you feel there should have been a committee. In another instance, you say it's good. How you?
In one, please. You see, we need to pay attention. Otherwise, we risk creating the impression of a contradiction. I have always held the view that it is not every infraction that will merit an Article 146 removal process or proceedings. And therefore, certain issues, we need to let them slide, right? Unless they are very grievous. And so I took the position that in the case of the Chief Justice, it was not grievous enough. And my position was supported by the likes of former Chief Justice Sophia Ekufu. In the same token, I think that, look, when you are in a position, there are certain infractions likely to commit. Are we saying that at the of the Constitution, for instance, by the President, if an impeachment proceeding should be triggered against the President? If the President is suspected, being human, to possibly breach the Constitution, right, in the course of his duty, not intentionally, but sometimes through inadvertence, and therefore it's not every constitutional breach that would merit an impeachment proceeding. I expect that the same threshold or the same standard would be applicable to other constitutional office holders or independent statutory bodies. That really is my position.
Yes, but Nana, if you make the point, that
let me answer the question, please. Let me finish so that there's no doubt. That is why I say that if we were to go by the justice to Tokonu antecedent or precedent, what would have happened would have been setting up a committee to look into this matter. But in this instance, the President has found it necessary, or the Chief has seen that it is not every infraction that would merit an Article 146 proceedings. That is my position.
Okay.
So there's no ambiguity, there's no contradiction.
Okay.
It is to position that, look, we should always make the threshold higher and also accept that being human, in performing human duty, right, expected of us under the law, there will be breaches, and that it is not every breach that will necessitate removal proceedings. Otherwise, every single president of this country would have suffered an impeachment proceeding. If it cannot be done to the president, then why other institutions? So we need to be careful. The threshold should be higher. That is my position.
Okay. But if you say, for instance, Agyei Baffour Awuah, that based on serious constitutional questions, if the allegations raise serious constitutional questions, and serious constitutional questions would warrant further probe, doesn't that suggest that it will be important to then set up a committee to go into it?
Otherwise, there wouldn't have been the need to establish a prima facie case. The necessity to establish a prima facie case is for somebody to pass a judgment based on the threshold, which threshold continue to be imaginary. It is on that score that we say that to ensure that there is no abuse of discretionary power and discrimination in the exercise of that discretionary power. That is why there should be a statute. But the necessity to establish a prima facie tells you that it is not in every situation that a committee would have to be constituted. However, when you judge it by a certain precedent where the threshold was lower, and in this instance where we appear to be raising the threshold, then the question would be, right, is the discretion being exercised fairly in a candid manner, in a manner which is not capricious? If that then is the case, then we need to ensure that we avoid the abuse of discretionary power in the exercise of the 146 duties. That is why I have consistently recommended reducing that into a statute. At the very least, there should be a CI governing the exercise of that discretion so that it's removed from abuse.
Okay, great. So let me bring in Suleiman Abrahama in at this, and then I'll get to Honorable Phyllis Kwachofosu. But Suleiman, so briefly, what do you make your initial thoughts on the dismissal of these petitions?
Well, thank you very much. I think that in building our country, we've chosen to be governed under a constitution. And the constitution prescribes what has to happen at any time when there are concerns, such as people not feeling that somebody is performing their role very well, or people having evidence against someone, for which reason they would think the person has to be removed. In this case, we are talking about the EC leadership, the chairman, the chairperson, and the 2 deputies, and the office of the special prosecutor. And I think that the Constitution under 146 makes it clear the processes to be followed. And it is good to note that the processes were followed. Now, the Chief Justice, who is mandated by law, by the Constitution, to look into the complaints and establish whether there is a prima facie case or not, comes out to say there isn't. And the President, therefore, cannot do anything. The Chief Justice cannot proceed to establish any committee as required by law. And so for me, what is fulfilling is the fact that we are at a time when institutions are working, the laws are working the way they are supposed to work, and we have moved on from the period when things were so predictable that if, for example, on June 25, Esedun Ketia on one of your networks did say emphatically that the leadership of the EC must go. The chairperson and the 2 deputies must go. At a different point, the general secretary of the party had said the same thing, and at another point, another person from the leadership of the party had said the same thing. I believe maybe if it was another some time ago, one would have said, well, given this, it is so predictable that this is what is going to happen. And so for me, it is gratifying to see a situation where the leadership of the party appear to have taken a certain position. A petition has been filed. The President acts on the petition as required by law. The Chief Justice, on the other hand, does what he has to do. And as per law, the matter has been established. The matter has been concluded. And so for me, this is the country built. And the Chief Justice, in his conclusion, as captured in the letter that you referenced to one of the petitioners, makes it very clear that, yes, some serious constitutional questions are raised. But to think that or to say that somebody or an institution's performance is very controversial, is suboptimal, is not to the satisfaction of a certain group or something like that, cannot absolutely constitute grounds for, to say the threshold has been met, and therefore a committee cannot be established. And let me touch on the bit about the portion that says some serious constitutional questions have been raised. Mm-hmm. I think the wording is important. Having constitutional questions raised, I think, is different from raising issues of constitutional breaches. For example, SAL. I think we were all unhappy that we have a particular part of the country not represented in Parliament for 4 years. Ablekuma North. I think we were all unhappy that for 6 months, a constituency in the country was not represented in Parliament. And of course, the Constitution makes it clear that every jurisdiction in this country shall be represented in Parliament. So to say that one, part of this country, South, was not represented in Parliament for 4 years definitely raises a constitutional question of lack of representation. But what accounted for that? The administrative issues that happened and all of that. Was it a constitutional breach? And so it's important to differentiate between an act of constitutional breach, which I definitely think should therefore merit an inquiry, from an issue that raises a constitutional question. If there's a constitutional question, we need to address the constitutional question, but not to interpret that as a definitive breach of the Constitution.
But Suleiman, yes.
Winston, let me make this point quickly. Mm-hmm. Unless there's a constitutional question, there will be no determination as to whether or not a constitution has been breached. Mm-hmm. So they are not distinct. They may be distinct, but not mutually exclusive. Because a constitutional question is the foundation upon which a determination is made whether or not there is a constitutional breach. Right? Mm-hmm. And so, if there is a constitutional question, then it might be necessary to determine whether or not there is a constitutional breach. and the breach may be another foundation to determine whether or not a prima facie, it constitutes a prima facie case against a particular person against whom a petition has been submitted. And so, very respectfully, I wanted to correct that position. Now, to say that, because I'm going to go into courtroom very soon. Let me make this point quickly, and I'll go. To say that we have moved from an era where the system was so predictable, I think that I think that might be quite prejudicial, for want of a better word. Very respectfully, if you have a better word, you can fill it in for me. Uncertainty itself is predictability. When you have a situation where the situation is uncertain, right? It is predictable because you know that in this situation it is uncertain. So uncertainty in and of itself is predictability. That said, what is also predictable, right? What was predictable in the past, right? For instance, a petition was sent for the removal of Justice Gertrude Tokomi. Okay. The previous administration, in consultation with the Council of State, found no prima facie case in that instance. Today, there's a petition pending against the CJ. What has government done about it? That petition has been ignored. And so, if you come and say that previously there was predictability, today there's predictability as far as the government's position in respect of a petition against the current Chief Justice is also concerned.
Okay.
And so let's not very respectfully overlook certain facts and create an impression that something is happening today that didn't happen yesterday. There was a petition, even under Nana Akufo-Addo's government, the petition that was brought against Justice Tokomi, there was an elaborate ruling, an elaborate reason as to why it did not establish a prima facie case. Today we are even denied that. And so between the two, where somebody will exercise a discretionary power but will not exercise it in a vacuum, but provide reasons as to why he was exercising that power in a certain manner. And today, when we are not given any reason at all, today, a Chief Justice of the Republic has been removed, and the President has not uttered a single word on such an important happening. Please, look.
Agyei Baffour Awuah, before you go,
which is not biased, very respectfully.
Before you go, there's been lots of messages, questions to you that I ask you because you say that some of these things may not be a prima facie evidence, but some have asked, a lot of people have asked, so was Charlotte Osei's offence a grievous one to warrant her dismissal? They say I should ask you.
What was Charlotte Osei's offence? It was a breach of the Public Procurement Act.
Mm-hmm.
Right?
Mm-hmm.
That was the case. Was it not the case?
Yes.
The question would be, when you breach the Public Procurement Act, what is the consequence? When you breach the Public Procurement Act, it's a criminal offence. It is a criminal offence to breach the Public Procurement Act. It is for all of us to determine whether a breach of or a commission of an act that constitutes a crime amounts to a prima facie case. It is for all of us to determine. Right? And so you have to look at it from this perspective. Is it possible for a person holding an office to be convicted, go to jail, come back and serve in the same office? Is it possible?
Tell me, is it possible?
No, I'm asking you, is it possible?
And I'm throwing it back to you.
No, I'm saying, how would you find it? Will you find it acceptable that a person is convicted, right, goes to jail, comes back to serve as the Chief Justice of the Republic of Ghana, goes to jail, comes back to serve as the Special Prosecutor, goes to jail, comes back to serve as the Electoral Commissioner? Do we as a nation find it acceptable? If we find it acceptable, then you would say that the removal of Charlotte Osei was not wrong. But if we don't find it acceptable, and there is no challenge as to whether or not indeed there was a breach of the Public Procurement Act, then of course there is a case. It is for us to judge.
Okay, hold on a bit. Let me just bring in Felix Kwachu.
I'm going into court, so please.
Okay.
Excuse me. Okay. Thank you very much for calling me.
Sure.
If I may just briefly react to some of the positions or statements made by my.
Yes, Sulemana, yes, go ahead. Hello, Sulemana? Okay, maybe we can just get to Felix Kwachu. I think we've lost all of them. We'll try and call everybody. We'll call Sulemana and also call Felix Kwachu so we can continue with the conversation. Mana Brahma back and Felix Kwachu. So, yes, Sulemana, you wanted to make a point. Please go ahead.
Yes, I actually don't know at what point the line dropped off, but I was making the point about Honorable Baffour Awuah's point about uncertainty being predictable. I don't think that uncertainty is predictable. I mean, if there's a match between Barcelona and Inter Milan or whatever, and these two teams are known to, at different times win, I don't think that we can say, well, it's uncertain, but it's predictable. I think that is quite contradictory. The other point is the distinction between the point that the CJ makes, that constitutional questions have been raised versus constitutional breaches have occurred. I see these to be two different. But in Honorable Awuah's trying to counter that, says, well, when there are constitutional questions raised, that might be grounds for establishing a committee to go into the matter. But the use of the word might in itself suggests to you that it's not a must. Then the CJ concludes that, well, as far as his inquiry into the matter is concerned, there isn't anything established to be able to warrant the establishment of a committee. And remember, the CJ cannot go on to say, I am establishing a committee to establish whether a prima facie case exists. As soon as the CJ establishes a committee, what that means is that the CJ has established that there is a prima facie case and the committee must go into it. But Honorable Awuah makes it look like, well, if there were constitutional breaches, that would be the reason, or that might be the reason to establish a committee to go into it to find out whether there's a prima facie case. I don't think that is the position of the law, even though I'm not a lawyer. For me, as I said, the most important thing is that as a democracy, we want institutions to work independently. And not only working independently, but be seen to be working independently. And for me, if you have a situation where, for example, the leadership in parliament of the ruling party, a supermajority ruling party, decides to introduce a bill in parliament to sort of remove the law that establishes the office of the special prosecutor, and then the president steps in, and that whole process is abrogated. You have a situation where the leadership, the core leadership of the ruling party, decides that we want this person to go. In our view, we think these people must go. They have been unfit for purpose, and so on and so forth. Then the process is triggered. A petition is filed. The president acts on the petition by forwarding it to the Chief Justice as required by law. The Chief Justice says, well, these petitions do not establish grounds for a prima facie, and therefore the matter ends. And the president decides to go by that. Of course, has no choice. I think my colleague, my friend, also talked about Tokonu quite a lot. I believe that we need to let audience know at least the little distinction between the two. In the case of Tokonu, the Constitution says under Article 146(6) that if the matter is about removing the Chief Justice, the President, in consultation with the Council of State, will establish a committee. And then the membership of the committee, who is supposed to be on, not in terms of the individuals, but so two Supreme Court justices, one of whom shall be the chairperson, and so on. The president goes ahead to do that. And then the Constitution says that when the committee makes its recommendation or its decision, the president shall go by it. The committee decides that, well, the Chief Justice should be removed. And what do we expect the president to do? The president should say, no, I disagree, and breach the Constitution. So I think the differences are clear.
Okay.
In the context of these ones, It is the Chief Justice who will look into it. If there's a prima facie case, the Chief Justice will go ahead and establish a committee, and then the committee will come up with a report, present it to the Chief Justice, and then the decisions are made. So I think it is important, even as there are disagreements over processes and how the former Chief Justice was removed and so on, we should not confuse people as though the processes are the same.
Okay, let me bring in Felix Kwachofosu, who's Minister of State in charge of government communications. Okay, we're told that Felix is not on now, and so let's continue. But Suleimana, so the point about constitutional questions. Now, if for something to warrant a prima facie evidence is the fact that there probably are questions to be answered, then the committee would establish that. So if on the face of it, there are constitutional and administrative questions, is that not enough reason to say, let's go into it and then determine whether these questions amount to breaches or otherwise?
Well, Winston, you see, I don't think that our Constitution is a perfect document. And I believe that is why over the period, there have been different attempts to try and review or revise our Constitution. Under President Mills, there was an effort. Under President Akufo-Addo, there was an effort. And under Mahama now, there has also been a process to try and review the Constitution. So at all times, I believe that there will be issues that raise constitutional questions in terms of, does the Constitution make provision for this? In doing this, does it not sort of raise issues that will require that the Constitution is amended this way or amended that way to tighten it up? So, for example, when Honorable Baffour Awuah was speaking, he made the point that he is of the position that Article 146 or the processes outlined for the removal of certain category of persons needs to be codified, that it needs to be backed by law and all of that. What that suggests is that for some people, there are constitutional issues that need to be addressed in order to tighten up that whole process of deciding when to remove and when not to remove someone. So our Constitution is not a perfect document. There will be questions at all times. What for me is critical is if there is a constitutional breach. Indeed, if there's a constitutional breach, then whether we agree with the Constitution or we don't agree with the Constitution, there's nothing we can do but to inquire into the matter. In which case, talking about this particular development, then the Chief Justice would have had no option but to say that, well, since there's a constitutional breach, the matter should be looked at and a committee is established for the committee to come up with its findings. But I don't think we should interpret issues raising constitutional questions to be something that amounts to constitutional breaches per se.
Okay. Suleimana, finally, why is this decision relevant for our democracy?
Well, I think in a democracy, when you find that institutions are independent and strong, I think that is really helpful. And to have a situation where, as I said earlier, you have the leadership of the ruling party making a decision. And of course, we've come from a period when, right in the days of the NDC in opposition, the commentary and so on and so forth was absolutely not too good for the Electoral Commission. Again, to be honest, we got to a point where almost every decision of the NDC, of the EC, was sort of always in line with what the MPP says their position is. So whether it is about whether people can use their birth sets to decide to validate their citizenship, and all the decisions that were made, it got to a point where it was almost like, okay, the EC says this, the MPP says we agree. The MPP says this, and it appears to be the same position as the EC. I think at that point, the NDC expressed a lot of concerns, antagonism, which is not unique, because at all times, the opposition would always be against the EC or speak against the EC's decision, and we are beginning to see that now. So if we've gone through all this, and then the party comes to power, and the leadership of the party says these people must go, and then a process is rolled out in the end, the Chief Justice says, well, nothing has been established, and the person, the people stay in power. And remember that we are also talking about a Chief Justice who was recently appointed under the same government. So for me, it is fulfilling that we have institutions that appear to be independent, strong. Not too long ago, the Supreme Court, for example, made a decision about the Pandai decision by the High Court. And I think that was, again, another evidence of institutions working. It is not about the wishes of the government in power. It is about what the law says, and it's about the interpretation of the adjudicating bodies. And that, for me, is what would make our democracy strong and resilient. And that's why I'm happy about this decision.
Thank you very, very much, Suleiman Abrahima, for joining us this morning. Suleiman Abrahima is Executive Director of the Media Foundation for West Africa.